Hello there. The General Assembly convened August 18th for a special session to consider pandemic-related budget changes and criminal justice reforms. The criminal reforms have the potential to change a lot of things for those who practice criminal law. Virginia Lawyers Weekly asked State Senator Scott Surovell to talk with us on Zoom about some of those changes coming soon to a courthouse near you. Scott, thanks for being available.
Happy to be here and talk to your listeners, and I love your optimism. Knock on wood about them being a pass soon.
Well, something's going to pass, and soon is the flexible term, maybe. One of the changes that could affect criminal practice is if it gets through in some form at some point, the expungement or sealing of criminal records. The bill that's on the plate at the special session had a list of crimes subject to automatic expungement. Tell us what's happened with this and how it would work if it's signed into law.
Yeah, so the majority leader, Charnel Herring, state delegate and attorney from the city of Alexandria, cares very deeply about this issue. And she sees automatic expungement as being a significant equity issue to help people get their get back on their feet and get their lives restored after they've proven themselves law-abiding after a period of time. The bill actually went through the Crime Commission. And just to understand how we got here, last session, there were 5 or 6 expungement bills filed in the Senate. There was like maybe 20 filed in the House. And I think Delegate Herring looked at how many bills were filed and said, I need to put all this stuff on ice, and we need to take a broad look at it instead of trying to do these one at a time with all these different ideas pending. And so automatic expungement, she really got into. She put it through the Crime Commission. It got vetted by staff. And then when the final, I'm not on the executive committee, so I didn't get to be part of the real process where the bill got drafted. And when the bill came out, I had a lot of concerns about it. I was one of 2 members on the Crime Commission that voted against it. And now it's introduced in the House. It's come out of the House. It's over to us. And the version that's currently in front of us does a number of things. Number one, it says that anytime a case is dismissed or null-prossed, the charge would be automatically expunged pretty much immediately unless the Commonwealth Attorney raises some issues, and there's certain standards that a Commonwealth Attorney might be able to kick an automatic expungement. But they have to affirmatively file something to do something about it every time a case is null-prossed. The bigger thing that it does is that there's a list of about maybe 40 crimes, probably about 10 Class 6 felonies, and then about 30 misdemeanors that after an 8-year period of time, if you're law-abiding, don't get in trouble with the law, you've complied with probation, the charge would be automatically expunged after that period of time. And it would make Virginia the first state in the country to automatically expunge felony convictions. These are convictions, by the way, not dismissals and not null process. These are convictions. Make Virginia the first state in the country to automatically expunge felonies. There are 2 other states that are currently doing some form of automatic expungement, but neither of them do felonies. There's 2 others that are in process of doing automatic expungement, but haven't figured out how to do it yet. There's also a process where certain employers might be able to look behind that, like law enforcement agencies or employers that are involved in national security issues and have a requirement under federal law to vet people a certain way. But this area of the law is extremely complex. So right now we have this automatic expungement bill pending. The Crime Commission is going to look at petition-based expungement in the next few months. There's a study going on for barrier crimes that Senator Edwards carried last session, which is supposed to result in legislation for the coming session. I introduced a bill studying data brokers, which are these private companies that buy and sell data about people's criminal backgrounds. And that's being studied right now by the Joint Commission on Science and Technology. And this whole expungement issue has a lot of different facets to it. And from my perspective, it needs to all be resolved holistically if we're going to take as big of a step as automatic expungement. And we can't just sort of pick that little piece out and start expunging like heroin possession before we expunge drunken public convictions. Or, so my guess is that we might take some small steps this session to do a little bit of expungement adjusting, but doing something as big as automatic expungement, I think, is highly unlikely in the special session. In the regular session, I think petition-based expungement for convictions will be on the table. Automatic expungement will be on the table. I think doing something about barrier crimes where you can petition to get permission to have a certain job if you have a certain conviction might be on the table. And also improving our ability to hold private third parties who sell information about people's criminal histories, hold them liable. So I think that's all going to be on the table, and all those have to be resolved together if we're going to do this correctly. And I would also just note that there's also a big distinction between expungement and sealing. And in some states, you can get certain things expunged, but yet other things sealed. And it for a lot of different reasons, I think it's important to have certain records hidden, but still available for people to look at for certain jobs. For example, if you're trying to hire somebody in childcare, or you're trying to hire somebody who's going to have keys to every apartment in the apartment building, or if you're trying to hire a teacher or somebody that's going to manage your books, how many people who want to go out and hire a bookkeeper, who has a history of embezzlement or, larceny, or, has drug addiction issues through the years. These are things you need to know before you hire somebody. So there's a lot of issues to look at that we're still trying to work out. But that's sort of what the playing field is right now.
House Bill 5062 would require a court to grant a prosecutor's motion to dismiss unless there were evidence of bribery or bad intent. And I'm thinking some judges are going to think this will take away their discretion to consider the propriety of a nolle pros motion, a debate that's ongoing in Arlington. Has that been discussed, and where does the bill stand?
Yeah, so there's actually two bills. There's House Bill 5062, and then there's also a bill that I put in that I'm carrying, which has a different way of doing the same thing, plus an SIS remedy in it to resolve a part of the STARS fight. My bill is Senate Bill 5033, but yeah, we've had two jurisdictions where the courts have basically been resisting null processing marijuana possession charges, Arlington and Norfolk. I've heard there's been some issues in some other circuits, like in Loudoun, and maybe there was one other. But in any event, Delegate Mullins' bill, he's the chairman of the criminal subcommittee, and he's also an assistant Commonwealth attorney in Hampton right now. So he's very familiar with the issue. His bill would say that a court has to grant a motion to dismiss if there's an agreement of the parties, unless somebody shows there's bribery or some kind of racial animus involved, which to me would be kind of, I guess there could be a racial animus against the victim or something, which might result in a dismissal. My legislation takes a different approach. My legislation basically says that cases can be null pros for good cause, and then it goes on to say that these three things can constitute or are definitely good cause. And it's like prosecutorial resources, policy considerations by the Commonwealth attorney, stuff like that. And something is going to come out. Mike and I have been talking a lot about trying to resolve that. I think we're very close to having an agreement, but there's going to be, I think, some solution to this problem. And yeah, I think it is intended to limit judges' discretion somewhat. But we're going to have something. When I introduced this bill in the regular session, my colleagues, Democrats and Republicans, all the lawyers on Crim Sub in the Senate looked at me and said, "Well, who's ever heard of a judge not null pros in a case? This is stupid." And they took that part out of my bill, and I kept telling them, "No, it's going to happen." And they're like, "No, it's not." And I was like, "Yeah, it's going to happen. Just watch." And then it happened. And so, and by the way, as a Democrat, some people would accuse me of being a liberal progressive Democrat. Some people pointed out to me that there's two sides to this, is that, while prosecutors in Northern Virginia might drop marijuana charges, prosecutors in Southwest might want to drop gun charges. And, this might limit their discretion in those scenarios. And my reaction to that was, you know what? That's why we have elected prosecutors. I mean, if that's what the voters want, that's what they get. They don't like it, they vote them out. That's our system. Prosecutors have discretion. So that's sort of where that stands right now.
Yeah, it's interesting. Which is moving the line of how far the discretion goes.
Yeah, and by the way, Peter, what I'm really hopeful about is my bill, in addition to having that prosecutor discretion piece in it, also has a provision in it that would allow any criminal charge to be continued for dismissal or reduction in a plea agreement with the agreement of the Commonwealth. Not over the objection of the Commonwealth, but only with the agreement of the Commonwealth. So it would resolve that STARS issue. So we could get back to the place where we were for the last 100 years, where you could enter a plea deal, do community service, drug treatment, mental health, whatever, and get your felony reduced to misdemeanor or get your misdemeanor dismissed or something like that for good conduct. I'm hoping to get that resolved too this special session.
Deferred disposition. Yeah, that has been contentious for 10 years at least.
Yeah, right.
Yeah. The proposal to address qualified immunity for police would have created a state court action for excessive force and other civil rights violations by officials. Since this idea is liable to come up again at some point in the future, tell us how that would work.
Well, the idea is to basically create a state-based 1983 action. And, you know, the 42 USC 1983 was adopted, I think it was like 1871 or something by Congress after you had all these,
after the Civil War and
right.
massive, during Reconstruction.
Right. It was right after Reconstruction when all these southern states were basically refusing to give African Americans any of their constitutional or statutory rights. And the idea was to be able to use the courts to bring these states into line. And it was kind of a forgotten statute, I guess, until about the 1960s when people started using it again. And then in 1981, I think, the federal courts created this whole qualified immunity concept, which says that if there's not a clear decision saying something's unconstitutional or illegal, then you have immunity for it until a judge says you don't. Then after that, you can get sued. So this basically would say, the bill that was in front of us basically said, if you can show that a law enforcement officer didn't, under color of state law, denied you a constitutional right, either under the U.S. Constitution, the state constitution, or any right under federal or state law, then you could bring a civil action against them for damages. You can recover actual damages, punitive damages, and attorney's fees. And so that's basically what the law proposed to do. And I can, you know, there was a lot of concerns. It came out of the House. It had like 2 or 3 lives in the House before it finally popped out, and then the Senate took it up, and we tabled it for a study in the Senate Courts of Justice Committee. I mean, I can talk about some of our concerns if you want me to point that out. Or
is it likely to emerge again in the special session?
I hope not, because we really don't have time to talk about it right now. I mean, you know, I'm trying to practice law right now and be a legislator at the same time, and it's, you know, putting your practice on hold for session is hard enough, but trying to practice law and be in session at the same time is a complete nightmare. And we really don't have time to have the kinds of discussions that we need to have to tease it out. But I think there is a solution to the issues that we had with the bill. And I think you will see some solutions proposed. I intend to propose one for the regular session, but I don't think we can resolve it in the special session because of the complexity involved and the number of stakeholders that need to look at this and vet it so that we're sure we're not making a big mistake and doing another special session to fix a screw up. But the short version is I just think if we could focus something that's solely upon sort of use of force complaints. So you're talking about when law enforcement, you know, hurts somebody, beats them up, when there's an injury situation involved. To me, that's really what we want to address. And not, you know, somebody's angry because they feel like the cop picked on them when they used their turn signal and wrote them a ticket. I mean, so, and also we just need to be very careful about how we do it, because the Constitution of Virginia has all kinds of stuff in it that the federal Constitution doesn't have. And when you give people a right to sue for a violation of any law, the police do a lot more than just put handcuffs on people. And so, you know, there's, the qualified immunity repeal is actually supported by the Second Amendment Foundation because it sort of weaponizes the Second Amendment against government laws. And it's also supported by some sort of Christian fundamentalist sort of litigation groups because they want to use it to sort of weaponize the First Amendment against government action. So we have to be very careful about how we put the guardrails that we put on this new lawsuit cause of action.
What other justice reform bills might affect Virginia lawyers?
A lot.
A lot.
Yeah. So I just talked a moment ago about the deferred disposition statute, which not many people have talked about, but I think could benefit thousands of people a year if it's actually signed into law by the governor. If we get back to a point where we're doing deferred dispositions, I think there's a lot of prosecutors that want to work out more creative plea deals that don't involve convictions or convictions of the crimes you have to plead to. We want to incentivize people to rehabilitate and get mental health treatment, et cetera. And by the way, my deferred disposition bill also provides that at the conclusion of that deferred disposition, there could also be expungement. So, so that I think, if it passes, would be a huge thing. We also passed a series of bills to cut down on one bill to cut down on racial profiling, and
The pretext stop.
Yeah, it turned that bill turns a bunch of different offenses into secondary offenses that a prosecutor that a police officer not only can stop you for, but the version that we're working off right now specifically says that any evidence gathered subsequent to a stop for one of these secondary offenses would be inadmissible, which right now, that's not the law. Right now, it just says they can't write you a ticket, but doesn't say anything about if they break the law and write you a ticket, they see something, they can still use the evidence, right? So this is a statutory exclusionary rule. In addition to that, that same statute also has a provision that says that a police officer cannot place you under, or cannot search your person or your vehicle based solely upon odor of marijuana, and that any evidence gathered pursuant to such a search would also be inadmissible. And so, I mean, I just had that situation yesterday, for God's sakes. I tried a DUI yesterday where the police officer claimed my guy driving down a 6-lane road, they were going opposite directions. He claimed that the marijuana smoke came out of my client's car, jumped across the road into his lane and into his car and into his nose fast enough for him to smell it and turn around, do a U-turn and chase my guy down. So, I mean, this happens all the time. That was the case I tried yesterday. And I've got another one pending just like it where, the officer smelled something and, you can't challenge that in court, right? And so now that marijuana is a civil infraction, we just don't believe the government ought to be able to search your person or your car based on a violation of a civil infraction like that. So that's one big set of laws that's out there. We have the earned sentence credit is going to get people out of jail faster if we pass that, which I think is likely. We're going to have an opportunity for people to get parole if they're terminally ill. I think that's probably going to pass. We also have, the big one. The big one is getting rid of jury sentencing.
Oh, shoot. Yeah. Sorry. That's huge.
Yeah. So Virginia is one of only 6 states in the country that still has jury sentencing. And there's a fascinating article. If you're a legal geek and you want to go read the article, it's a fascinating article. If you go Google it, it's one of the first things that pops up, but it talks about what the history of that is. And, there's only 6 states left, and they're all states that used to be part of Virginia as they carved off the states. All the Virginia lawyers sort of came out of here and marched west, and they took the Virginia legal system with them. And so like Kentucky and Tennessee and Missouri and stuff, I think. But that would be a big change. I think a big welcome change. There's a lot of people, I think, that end up pleading guilty to things that they probably would go to trial on if they didn't have to do if they didn't have to do a jury sentencing. So I'm optimistic that'll pass. And by the way that bill is written right now, it would be jury sentencing at the defendant's option.
Right.
The Commonwealth will not have an option, and you'd have to make an election 30 days out from trial as to whether you want to go judge. You have to put in writing whether you want a jury or a judge 30 days out, or else it's a judge sentencing. So that's the current posture of that. So that's a few of the big things that are still around out there. And the police reform, the assault on police officer bill, that's my legislation. It's still pending. There's some members on our side, my side of the aisle, they're the Democrats in the House that are a little nervous about that bill.
It simply takes away a felony charge of assault, or
the original bill did.
Okay.
But the version that passed the Senate basically eliminates the 6-month mandatory minimum sentence. It also says the charge cannot issue unless it's investigated by an independent police officer and signed off on by a Commonwealth attorney. And the third thing is that a judge or a jury can reduce it to misdemeanor if they find the person is of slight culpability, and either there's no bodily injury or the person has reduced mental capacity or pervasive intellectual disability. And
right.
that misdemeanor concept comes, I borrowed that from the improper driving, reckless driving, improper driving dichotomy. And the independent officer piece, that was actually suggested by one of the chiefs of police in Virginia, who said that he thinks a lot of these charges happen because police officers have these encounters, come back really angry and want to light somebody up. And this is the only charge in the books that where the same person is the lead investigator, the victim, the lead investigator, the charging officer makes the charging decision, and the lead witness.
Right.
And so you have a built-in conflict of interest in all that. And there's about 2,000 of those cases a year that are brought. And I'm hopeful that if we were to pass that, you would only see it, maybe a couple hundred, maybe felony assault on police officer charges that are brought. And they would truly be situations where they ought to be brought, like this guy that just slugged the state trooper Henrico last week or a couple days ago. I mean, that's the kind of case where that ought to be brought.
Any chance the Assembly is going to elect judges in the special session?
I wish. I think it's highly unlikely, but I wish. Alexandria has a circuit court spot. Well, first of all, we have the Court of Appeals, and we have, I think, almost the longest Court of Appeals vacancy we've ever had in the history of the Court of Appeals right now. And the Senate, is ready to figure that out. We have a state corporation commissioner who needs to be elected. Right now, he's in a temporary appointment, but we agreed on him. But we have another SEC vacancy probably coming up. I think Mark Christie was supposed to be confirmed either this week or next week. So we have a second vacancy on the SEC. Alexandria has a circuit court vacancy, a J&D vacancy that they've agreed to fill. Winchester, I think, has a GDC vacancy that Chris Collins is currently sitting in as on a temporary basis, appointed by a circuit court. There's I think a J&D vacancy in Roanoke, and there might be a couple others around the state that are currently vacant that we could fill right now if we were able to do it. But the House, in their procedural resolution, specifically did not put judge elections in there for the first time in anybody's recent memory. So right now it's procedurally impossible to elect judges until the House changes their procedural resolution.
When's the session going to end? Ever? I mean, it's kind of on again, off again. You're a day practicing law and then 2 days in Richmond, that kind of thing?
Mm-hmm. I mean, I was in Richmond for Tuesday night, Wednesday this week. I got to go back next week, Thursday, Friday. I have a 3-day trial coming up. I mean, my theory, I could continue my trial, but it would be like the fourth continuance of a 3-day circuit court trial. I'm not doing that. So, we had one day we had a malfunction because Chap couldn't be there because of a trial, and constitutionally we needed 21 votes to do something. And so the session needs to end. I mean, special sessions usually come in with everything pre-programmed, and you get it done within 10 days, 2 weeks, something like that. We tried, but we never really figured it out ahead of time, is all I'm going to say. So, but I can't speak for the House, but at least in the Senate, there's a real desire to get this over with as soon as possible so people can get back to their jobs and their lives. So the budget is the biggest thing we came back to do, and that hasn't popped out yet, but I think they're trying to do that where they just reach an agreement and then throw it on the floor so we don't have to go back and forth and put it in conference and all that. So, but the budget's being worked on, and I'm pretty optimistic the budget will get figured out. It's this criminal justice stuff and some of the COVID bills that are still hopping around that are causing the delay.
Well, Scott, I appreciate you taking the time to update us on all this stuff. This is going to go up on YouTube, and today, as we're recording this, it's September 18th, because by the time some people see it, there's probably going to be changes in some of the stuff of what you said. So
there's two committees that were meeting today, and there's committees that are meeting Monday, Tuesday, Wednesday next week. So, some of these bills we were talking about might be dead or alive or who knows what by the time people watch this, but it's still going on.
Appreciate your time. Thanks so much.
Thanks for having me.